At this point, the court is not going to readdress bond. Bond will remain as currently set with the proceedings related thereto. There's also currently a preliminary hearing that is set for August 3rd and 4th. It's my understanding that we're going to continue forward with that preliminary hearing as anticipated. Is that correct, Mr. Wood?
Yes, Your Honor.
Mr. Pryor?
At this time, Judge, that is correct.
But the question is, will we see it? Welcome to Law and Crime Now, everybody. I'm Jesse Weber, and thanks for joining us. So the prosecutor in this case, Rob Wood, has asked the court to ban video recordings of the upcoming preliminary hearings for Laurie Vallow Daybell and her husband, Chad. Both have been charged with evidence tampering-related counts in connection with the discovery of Laurie's children, Tylee and JJ, who were found buried in Chad's backyard. Now, you also want a fun fact to talk about? In Laurie and Chad's belief system, July 22nd, 2020 is the day of the apocalypse, when there will only be a few thousand people left on Earth. Now, we were afraid if we would have a show. So far, we're okay. We'll see which way this goes. I want to bring in my panel. I'm joined by Law and Crime legal analyst Terri Austin and Julie Rendelman. And of course, when I talk about the Laurie Vallow case, executive trial producer Cathy Russon is with me. Great to have everybody here. Cathy, I want to start with you. Great that we have a show. We were concerned. But let's talk about this. The idea, there's one thing to read about a case. We'll see pictures of a courtroom. But the idea of not having these preliminary hearings recorded, what do you make of that? What do you think the public reaction would be to that?
Well, it's interesting because Prosecutor Rob Wood is saying that he's going to have a hard time seating juries in both these cases if the preliminary hearings are broadcast and live streamed. I mean, look, I hate to tell you, Rob Wood, there's nobody in this country that hasn't heard at least something about this case, especially in the entire state of Idaho. It really doesn't matter what county. They're inundated with this case. So I'm not sure that that's going to matter at this point. I know people are furious right now that it's a possibility we may not be able to broadcast the preliminary hearing. Now, remember, the judge hasn't ruled yet. The one thing that going in our favor to be able to see it and show it to everyone is COVID-19. The judge can't really let all the media and public into the courtroom. So he's likely going to have to let a feed go out. It's going to be a matter of, one, can we broadcast it? Two, can we record it so it can be viewed later? And those are all things the judge is going to have to take into consideration. Either way, I will be there in Idaho for the first preliminary hearing on August 3rd.
Yeah, I would have no doubt that you would be there, Cathy. Now, Terri, from a legal point of view, which way is the judge to side on this? Because there are a lot of people watching this. There are these kinds of First Amendment issues as well. And so you tell me, where is the judge likely to rule on whether or not these hearings, which, by the way, I have to tell you, we've all been waiting for, because there's a ton of information that investigators have not revealed yet, and we're all kind of in a guessing game to determine what they have, that were supposed to be revealed or going to be revealed at these preliminary hearings. So which way is the judge going to rule?
Well, if I had to guess, Jesse, I would say the judge would rule in favor of having the cameras and the live stream. And the reason is this. The prosecution, in its motion, actually acknowledged the fact that defendants have a Sixth Amendment right to a fair trial and a public hearing. So I think therein lies the issue. The right to have a public trial and a fair hearing is going to outweigh, I think, the fact that the prosecution does not believe it can get a jury who is going to be fair here. And to Cathy's point, everybody knows about this case. So I don't think that, that will help.
So let's talk about that, Julie. How on earth can you get a jury that either doesn't know about this case or hasn't formed an opinion of this case? I remember when we were covering Harvey Weinstein, that became almost an impossible task. But here in this local community where everybody seems to know about this, what would be potential solutions to get a fair and impartial jury for both Chad Daybell and Laurie Vallow Daybell?
So, I mean, the first possibility is to have the hearing, the preliminary hearing, not, not video recorded. And just, just to go back to that for just 1 second, we compare it to a grand jury proceeding. A grand jury proceeding in New York would be a secret proceeding. That would be the one proceeding in which the public is not allowed to, in a sense, see it. Obviously, a preliminary hearing is different because it's done in a public forum. And I do agree with Cathy that I think COVID makes it a little easier for the judge's decision because it's hard to keep a hearing in which it's done in more of a virtual sense, private. With that said, I think the options are, to move it to another jurisdiction, which I'm not sure we can move it to any jurisdiction. Similar to Harvey Weinstein, I think you'd have to move it off the planet in order for people to not know about it. But I will say, people that are watching this case or jurors don't have to not know about the case. They have to be willing to take whatever their opinion is or isn't and separate it from the evidence that they're going to hear in this case.
Yeah, no, that's a good point. Look, it's something that people have strong opinions about. And if we take a step back, the last time we saw Laurie Vallow Daybell was when she was in court regarding the misdemeanor charges she faces in Madison County. Remember, she's facing charges in 2 different counties, felonies in Fremont. But if we go to Madison, the judge in this case actually lowered her bail. Not that it matters because she still has $1 million bail in Fremont County, and clearly she hasn't put that up. But listen to the judge here talking about what the conditions of her release would be.
Of justice, Ms. Daybell is considered innocent until proven guilty. But every court in Idaho, in consideration of what bond should be set, is allowed to consider the likelihood of conviction and any mitigating or aggravating factors that may bear on that likelihood. I think it's inescapable that these misdemeanor charges are relating to the whereabouts of her minor children who have now been found deceased. All of the other factors are really no different than where they were when we had this last hearing. I am going to reduce bond based on my consideration of all those factors. I'm going to set bond at $50,000 on each count for a total of $150,000 in bond. If Ms. Daybell does post bond, I'm adding an additional condition to her release that she have no contact whatsoever with her alleged co-conspirators.
Cathy, no contact with Chad. Did that strike you as odd? And also, as we try to understand Chad and Laurie's relationship, my understanding is you're learning more details about Laurie's past relationship. So if you can speak about these points, I think that would really help viewers.
Well, I don't know if it's odd that the judge ordered that, because when you have conspiracy charges, they don't want them speaking to each other. One thing we know is those two are 2 peas in a pod. They're pretty connected. They're not going to turn on each other anytime soon. That could change down the road. I don't see it happening. We've learned a little bit more of Laurie's. We've gone over some of her divorce documents with previous husbands. And today I read some more of her second husband. Remember, Chad's her 5th husband. And what we see as a theme, I haven't read her first husbands, but now I know information about number 2, 3, and 4. And she's accused all of them of being physically abusive to her, emotionally abusive to her, and then some even worse things on some of them. Now, I guess it is possible that women can keep with the same pattern and keep marrying the same type of bad guy, but it does seem like she's always a victim in all of her marriages.
How convenient. Let me ask you a question here, Terri. We talk about it on every show. Neither Chad nor Laurie have been charged with murder as of this point. Now, what do you think investigators' theory is about who was involved in what? Because if I'm understanding the charges correctly, is it not that Chad and perhaps Alex Cox, who is Laurie's brother, were instrumental in disposing the bodies, but Laurie was not? Laurie maybe didn't physically dispose the bodies, but was instrumental in trying to cover it up. You tell me what investigators are thinking about the roles of either of these defendants at this point.
I think based on the evidence so far, the authorities are thinking that Alex is the one who actually killed both JJ and Tylee, and that Chad was the one who helped dispose of the bodies. Laurie, I believe, and I think the authorities think, was behind the whole scheme and actually got her brother, Alex, to do the bad deed. But the problem is they haven't charged either Laurie or Chad yet. And I'm not quite sure, Jesse, what they are waiting for. They found the bodies. They have all of the connections and the theories. So I'm waiting for them to actually bring the murder charges.
And look, Alex Cox is deceased, so clearly they can't go after him. Tell you what, I'm hoping that these hearings are recorded. We need to see what's going on. We're going to wait because this is something that people want answers to, and we're going to cover it here on Law and Crime. When we come back, more to talk about, and we're going to start with Ghislaine Maxwell. Bunch of updates there. Stay tuned.
Ghislaine Maxwell is in prison, and a lot of people want to know if she's going to turn in powerful people. And I know you've talked in the past about Prince Andrew, and you've criticized Bill Clinton's behavior. I'm wondering, do you feel that she's going to turn in powerful men? How do you see that working out?
I don't know. I haven't really been following it too much. I just wish her well, frankly. I've met her numerous times over the years, especially since I lived in Palm Beach, and I guess they lived in Palm Beach. But I wish her well. Whatever it is, I don't know the situation with Prince Andrew. Just don't know. Not aware of it.
Well, that's certainly a curious statement regarding a woman who's facing a 6-count indictment for allegedly luring and enticing underage girls for sexual abuse and then lying about it. Back here with Julie and Terry. Julie, your reaction to that, because I've read a bunch of comments, and there's everything from Trump's trying to protect himself, he doesn't know what Ghislaine Maxwell has on him. By this comment, he's signaling to her that if she were to be convicted of federal crimes, he might pardon her. Your view, are people reading too much into this, or is this perhaps he just wasn't prepared for this question?
You know, I think my favorite line was when he says, I guess they lived in Palm Beach. Of course they lived near him. He knew them. He knew Jeffrey Epstein. He knew her as well. I think he's never, with all due respect to our president, I don't think he's ever really prepared for questions that are asked of him. So this is nothing new. I think we're reading too far into it when we start to say that, you know, it's a sign that he's going to pardon her, anything like that. It's a flip comment that he makes often about many things.
Obviously, the insinuation here, the allegation is that somehow, President Trump, along with Bill Clinton, along with Prince Andrew, they're all within this orbit. They were all engaged in illegal activity. That's the main allegation here. Now, Terry, I want to turn to you because there's a lot to focus on Ghislaine Maxwell. Her attorneys have requested a gag order on the case, citing the comments that have been made by federal officials, specifically the U.S. Attorney from the Southern District of New York, Audrey Strauss, when she was arrested, when Ghislaine Maxwell was arrested. And they're saying these comments, calling Ghislaine Maxwell certain names in the media, is highly prejudicial. Your thoughts on a gag order in this case being put down by a judge?
I don't think that that is necessary here. And I say that because I think that Strauss was actually quite careful in the statements that she made. I think she didn't go too far. Sometimes we see, I think, the authorities or the police
I'll interrupt
DA.
you. I mean, at that press conference, other officials there called her a snake and evil and things of that nature.
Yeah, now, those comments I think were too much. And I do think you have to be careful because when you get to that point, you are trying your case in the media, and you could be potentially swaying, jurors who might be sitting on the case. So I do think that they might have gone too far. But Strauss herself, I think she was fair and even-handed on the comments. She simply said what the charges were going to be, and I think she was, as I said, not going too far. So it's interesting that Strauss specifically was mentioned because I think she specifically was the one who was being fair in her comments.
Julie, let's move on to another allegation. This allegation is that Ghislaine Maxwell, through a holding company, paid this far right-wing conservative activist to ultimately try to get the judge removed in the case, the prosecutor, removed in the case, and ultimately to have a smear campaign against the alleged victims of Epstein and Maxwell. This rumor that has been circulating, what are your thoughts on this, and does it hold any water?
I mean, we don't know. I mean, we're hearing that the company paid, I think it was $25,000 to try to either A, intimidate the victims, and B, do something to get rid of Jeffrey Berman. We see what happens. I don't think one has anything to do with the other. I think obviously time will tell. I assume the feds are going to look into that as one other aspect because, you know, part of the issue of her remaining incarcerated is some concern that she would potentially go, you know, intimidate or try to intimidate witnesses or victims in this case. And so that's just another piece of evidence that would support that.
Terri, let me ask you real quick. The judge, a judge, is also going to be determining whether Ghislaine Maxwell's prior deposition testimony in a civil lawsuit that's sealed would be released. And there are some graphic details there about her sex life. What do you think the judge is going to do here?
Well, generally speaking, what they're going to do is look at whether or not the, you know, prejudicial value is going to be outweighed here, whether or not it's going to be evidence that's going to help in the trial, whether it's probative. So I think that here, you know, the issues that were brought up in the deposition may not really be related to what's going on here at the trial. So yes, in fact, it was under oath, but whether or not it's really, you know, relevant to what's going on here and the charges that are going on here is something I think the judge is going to have to determine.
Well, there's always an update in that case, and we'll continue to follow it. I want to move on to a different case that we've been following here on Law & Crime Now. Reyshard Brooks, he's the man who was killed outside of a Wendy's after a police detainment, police arrest gone bad. Now, the attorney for one of the defendants, former Officer Garrett Rolfe, was actually charged with murder. They filed a motion to have the DEA, Paul Howard, recuse himself. I'll tell you what, let's actually start. You can hear Paul Howard himself when these Garrett Rolfe, as well as his partner, Officer Devin Brosnan, were arrested. Take a look.
We have concluded that Mr. Brooks was running away at the time that the shot was fired. Mr. Brooks was shot twice in the back. One of the shots was a center shot to the back that penetrated his heart, and it was done by a 9mm Glock. Now, one of the things that we also relied upon in our conclusion is something that is called under the law, referred to as an excited utterance, and that's when someone makes an immediate statement, and because it is made without the ability to consult with counsel or to think about it, under the law, an excited utterance is considered as highly reliable. And at the time that the shot was fired, the utterance made by Officer Rolfe was, "I got him." That was the statement that was made at that time. We also noted that Officer Rolfe was firing a taser at Mr. Brooks. The City of Atlanta SOPs, in fact, prohibit officers from firing tasers at someone who is running away. So the City of Atlanta says you cannot even fire a taser at someone who's running away, so you certainly can't fire a gun, a handgun, at someone who is running away.
Julie, let's start there. My understanding is one of the reasons the defense wants the DA off this case is because they plan to call him as a witness and say, you are saying one thing about tasers now, but you said another thing about tasers only, I believe, 10 days before. The idea of that Brooks was not a threat to the officers, and yet earlier on you said that a taser was in fact a dangerous weapon. They actually want to call him as a witness to talk about that. Your thoughts?
So, you know, regardless of what you think about the specific facts of the case, I do have some problems with this DA. I don't believe that many of the reasons behind, there's no argument that this DA is going to be able to be called as a witness. His opinions about whether or not a taser is a deadly weapon or not really has no bearing or relevance to the actual facts of the case. However, I do think the defense has many points in regards to the DA's behavior behavior leading up to this investigation, including his motivation, I think, politically in using this case to kind of benefit his politics and his reelection. And two, the fact that he himself is being investigated by the GBI for his own misconduct. So I think there's problems with him. At the end of the day, I don't think the judge is going to recuse him, but I think it would benefit the prosecution if he wasn't touching this case too much.
Terry, we talked about this on an earlier show that, as Julie said, yeah, he is being investigated, including for his use of subpoenas, his use of funds, and how he used that to possibly supplement his own salary. Do you think at the end of the day this becomes a question he's too controversial a figure with such an important case and he may be set aside? And if that's the case, Terry, who takes his place and how does that affect the further proceedings?
Not only might he be set aside, but I think because of all of the issues occurring, the fact he's being investigated for funneling money to his own private account and the way he looked at this educator's case and gave them some leniency, even though they were found guilty, and a plethora of other issues, I think he should consider stepping down himself and setting himself aside. And to your second question, there are many other DAs who could take the case. He could still be behind the scenes, but as far as a public front, they could put another investigator. We've seen in other cases, particularly in Georgia, where they go from one prosecutor to another. So I think that they could do that in this case, and it might bode well for the prosecution if they did that.
I believe these are the conversations that are being had right now because, again, there's so much at stake here. There's a lot of important factors here. And it should be noted that the DA's office has said that they haven't responded to this recusal motion yet, but they will at a later date. We'll take a break. When we come back, we'll focus on an update in Elijah McLean's case. Stay tuned.
Happy birthday! Happy late birthday! It's delicious. Happy super late birthday. Nice. Wait, really? No, really? I was like, no way, this is a luau party. There you go. Wow.
That's Elijah McLean, the young man out of Colorado who was detained by police, given a shot of ketamine, went into cardiac arrest, and then died several days later. Now, there have been no criminal charges filed against anybody in this case. That's currently being reviewed by the state AG. However, there has been an update. The city council in Aurora has officially passed a resolution, a measure, to appoint a 3-member team to conduct an independent investigation. I want to bring in homicide detective Dr. Kenneth Lang, who's joining Terry and Julie. Doctor, great to have you here. So we see that this team is being led by Jonathan Smith, who's a former DOJ lawyer. He actually handled overseeing the investigation of the death of Michael Brown out of Ferguson. And my understanding is that this team is not going to determine whether criminal charges should be filed, but whether there should be changes in police tactics and policies, possibly the first responders here. How do you imagine this could play out?
So it's really important that we do have transparency with our investigations, particularly those that involve police officers involved in death investigations. So serving as a homicide detective had the opportunity to serve or to investigate a number of investigations where people had died at our hands. And so when that happens, we've always welcomed in my agency the ability to bring in another entity and to get a different viewpoint of that investigation. So with this, I could see perhaps the ability of some new legislation coming out or even new training tactics for officers in regards to this type of conduct.
You know, I just want to give everybody a understanding of exactly what this situation looked like. So I warn our viewers, what you're about to see is disturbing. This is the body cam footage of the arrest. It's just a sample of what happened to Elijah McLean, but I think it's important to show to give a sense here. Take a look.
Relax, just relax. Relax, relax. Relax. All right, bring that arm back. Give him a couple.
Got his arm back. Where's his other hand? Good. We got it right here. It's in a bar hammer. Okay. Stop. Okay. Stop. Okay. All right. Side. I'm going to straddle him. Figure for his legs. Recovery position. Trust me. Recovery. I have his legs. I have his legs. Where's his left body? It's a new 18. We got him. Still fighting us in the ground. My name's Elijah McLean. Yeah, that's all. I'm here to use carotids. That's what I was doing. I was just going home. Why? I'm an introvert and I'm different. Come out? No. Was he out? I heard some snoring. I just don't like completely. Going home. I'm just different. I'm just different. That's all. That's all I was doing. It was actually Rosenberg. I'm so sorry. Your gun, dude. I have no gun. That's where I tried karate. I don't do that stuff. I don't do any fighting. Other units that are not here. Why were you telling me? I don't go to guns. I don't even kill flies. I don't eat meat. I'm not a vegetarian. I don't judge people for anything. I try to live a secret. When we showed him up, he was wearing a ski. And I respect all life. And walking, so I mean, that's on. Forgive me. Yeah. All I was trying to do was become better. We started it because he reached for Rosie's gun. And we had him on the wall. All right. And I'll do it. I'll do it. All right, what do you guys no other suspicious. Can you nobody else camera? My camera in the grass somewhere. To help all life. I will do it. Okay. One of you guys don't mind contacting
All right, Julie, we're watching this. Now we understand this three-member panel is being assembled. I believe 2 of the positions have not been filled yet. But whatever the findings of this team are, as again, my understanding is that I don't believe that they are going to be dictating whether criminal charges should be filed. However, could their findings ultimately affect the state attorney, the state AG's decision to ultimately file charges against the officers or even a first responder?
Absolutely. Keep in mind, I mean, there's so many questions still outstanding in this case, and people want answers. And obviously, putting together these 3 individuals in this panel to do a further investigation is a way to get some of those answers and potentially make some changes. But at the end of the day, if they come up with evidence that supports the need for there to be criminal charges against one or any of those police officers, they're going to be provided to the prosecutors, and potentially the prosecutors will use that in order to go forward with criminal charges if they deem them appropriate.
Right, and I think, people want answers not just for Elijah McLean, but also to our next case, George Floyd. Let's go there because there's a lot to break down here. The judge has officially lifted the gag order that was placed on the defense. This means that the defense can now make statements in a public forum. And remember, we're talking about 4 officers, or I should say 4 former officers who have been criminally charged in connection with Floyd's death. Now, the issue of use of force is going to be huge for the defense. And let's start right there, where attorney Tony Romanucci, who is actually one of the attorneys representing George Floyd's family, you recall that they have filed a federal civil rights lawsuit against the city and the officers. Let's listen to this idea of use of force by the police.
That use of force question is very important because the use of force, police we know are allowed to use force, but only commensurate with the force that is used against them. That's why it's called a continuum scale. And there's a scale in which you're supposed to follow, that if somebody continues to resist or is running away or is using some sort of force against you, that you're allowed to use a certain amount of force back. But when you look at this event, George Floyd was prone on the ground where there was force coming up from the ground, force being pressed on his back. He was compliant, he was restrained. Therefore, the force that the police were using turned into deadly force. They didn't have to use their gun on him or a taser or a shotgun. That knee became deadly force with every second that ticked away. Every second that ticked away, that was a Fourth Amendment violation. Now, please keep in mind, This is the civil case. The burden of proof on a civil case for the Fourth Amendment is a preponderance of the evidence standard. That means the way we explain it in court, if somebody tips the scales of justice this so much, we prove our case. On the 14th Amendment, it's deliberate indifference. It's a little bit of a different standard. On the criminal case, this is not the criminal case. That's beyond a reasonable doubt. That's a significant different standard. We're not here to talk about the criminal case. We're here to talk about the civil standards, the use of force that was used against them that turned into deadly force, which killed them because of training policies. Training policies that were bargained into the union contract, which gives away the ability for police officers to be accountable for their behavior and for Minneapolis to be less transparent. You're right. They have a reputation for being liberal, but if you don't change the use of force policies and train, you will have continued failures, as in the death of George Floyd.
I want to go back to retired homicide detective Dr. Kenneth Lang here, and we're going to get into the judge lifting the gag order, but I want to stick with this use of force because it's our understanding the court is deciding whether or not to publicly release the body cam footage. Right now, members of the media can actually go to a private appointment and view the footage themselves, but it's not allowed for public dissemination. However, the court is considering releasing it. It seems that the defense is keen on this. They want it released. So when we're talking about issues of did they use proper force here, what they were trained to do, and there doesn't seem to be a fear of the defense to have people view this body cam footage, what's your perspective, Doctor?
So it seems that the defense wants to use the totality of the circumstances from the officer's perspective, and they want to be able to get that out there into the public. But I'm not sure that I really see how this changes the outcome of this potential trial, in that the use of force was excessive in the George Floyd case. Beyond a reasonable doubt, we are trained that
well, Doctor, let me ask you this. If the videos were released, from your perspective, your experience, what are you looking for in those videos? So if they are eventually released, we know what to look for.
So if the videos are released, we're looking for the different perspectives to see what other viewpoints it has to offer for if George was resisting or not, if he was being combative in a different way. But I'm not really sure that we're going to be able to see that based on the video that we've already seen and what we already know.
Right. And I mean, look, it will tell a different story because we have the transcripts, but to see the visual will be a completely different story. Terri, let's move on to the gag order. The judge lifted this gag order, seemingly so the defense can defend themselves in a public forum. Was that the right decision? And although the judge said, look, you're still bound by ethics rules and what you can say, what do you anticipate these defense attorneys will do now that the gag order has been lifted?
Well, it's interesting because it was lifted. The judge reasoned that it was lifted because both sides actually, but the defense had a right to protect the interests of their clients. And also the judge said that people were violating the gag order anyway. So I found that to be interesting that the judge didn't want to enforce it and he just decided to give up and let the gag order rescind. And hopefully they will follow the law in the state and not, go beyond what they're supposed to say in terms of the ethics of the situation. But I did find it interesting that the judge lifted it, and part of his rationale was the fact that people are violating it anyway.
Terri, follow-up question. Were you surprised by the judge saying the Attorney General will not be held in contempt for the statement that he made while the announcement that he made while the gag order was in place, namely saying that different members have now joined the prosecution team? The defense had a big issue with that, said that violated the gag order. You're talking about now putting together this all-star team. That's prejudicial, yet the court ruled the AG did nothing wrong.
Listen, I think it made sense because the announcement was very benign. It just said that we have additional people who are working on the case and these people are very qualified. Yes, I suppose you could read into that it's saying, listen, we're gearing up. But the point was, it was a very objective statement. I do think, however, having said that, that when you have a gag order, I think both defense and prosecution should be very careful about making any statements at all.
And the news keeps on coming with this case, including the fact that Derek Chauvin is now being looked into failing to pay taxes. It's a case we'll continue to follow. When we come back, I want to focus on a case that we have been really concerned with here on Law and Crime, and that, of course, is the murder of Dan Markel. Big update. Stay tuned. Welcome back, everybody. Finally, let's get to the ongoing case of Dan Markel. This is the FSU law professor who was gunned down in his garage. The two killers, Sigfredo Garcia and Luis Rivera, are currently in prison. Rivera had pled guilty. Garcia was ultimately convicted. Now, Garcia's former girlfriend and alleged accomplice, Catherine Magbanawa, her first trial ended in a hung jury, so she's awaiting a retrial. And this is interesting because the main question here is about the Adelsons. That's Dan Markel's ex-wife's family, whom the state alleges was behind this hit. Yet no one in the Adelson family has been arrested or charged. Now, as we are in the 6-year anniversary of Dan Markel's death, his friends have formed a group called Justice for Dan, where they are actually petitioning the state attorney to arrest and criminally charge the Adelsons. The question is, will that work? But before we can get to that, let's go to some of the evidence that we learned during the course of this trial against the Adelsons. So Charlie Adelson, Wendy Adelson's brother, and again, the former brother-in-law of Dan Markel, it's believed that he was dating Catherine Magbanawa. And allegedly, he used her as the conduit to hire the hitman. I want you to listen to this wiretap recording, and it's between Charlie Adelson and his assistant at this dental institute, where she says authorities are trying to get records for Katie, because the idea here is that allegedly Charlie was paying Katie as working at the dental institute, although authorities say that was just a cover. He was really paying her because of the hit. So listen carefully to what he says on this wiretap recording.
Hey, what's going on?
You're asking for records for Katie.
For what?
That she works here.
I wouldn't.
They asked, did she work there? I was like, yeah, she works there, but I don't know what you want. Because remember we sent there.
Erica.
Yes.
Do me a favor. I'm not there right now. And I'm in surgery. But it's not my office. It's my dad's office. So I can't give anything out.
Right.
So, I don't have access to it. I don't know where anything is. I would not speak to anybody. Listen, you can talk to whoever you want. I shouldn't say don't talk to anybody. It's not my office. The office was sold back to my dad, actually, a long time ago. So tell them that it's actually, you're talking to the wrong Dr. Adelson. It's not your office. You can't get that record.
They said within 20 days of the Florida statute, provide a above cause with reason.
Are they there now, or are they standing?
They're there, but I'm in the back. I'm in the back. They're just waiting for me to come back.
Oh, and they want records?
Yes.
Do me a favor. I'm going to call you from a landline on your cell phone, okay?
Okay.
All right, bye.
All right, now we have a recording of Charlie and Katie where they're apparently using code words and code language, which begs the question, why would you be doing that unless, of course, you did something illegal? Take a listen.
So she picks up the phone. First of all, she sounds exactly like you on the phone.
She sounds like me?
What's that?
She sounded like me?
Hey, look, for a second, she picks up the phone and goes, she's in the bathroom. And I thought that was like some kind of code for something or other. She's like, she's in the bathroom. And I'm like, is she fluid or is she in the bathroom? My head's like spinning. I'm like, what is she trying to tell me? I was thinking like, I was about to ask her, has she flushed or is she still floating? I want it flushed. Make it go away.
The whole bathroom scene.
I want it flushed.
No, she wasn't flushed. Okay.
So I'm fucking thinking. I thought this was like code. I'm like, Katie, Is she flushed or is she in the bathroom?
Oh my God, it's too funny.
And then I'm about to tell her, well, call me back when she's flushed.
Stop, man. They're really getting us.
I made it clear I want the problem flushed.
Oh, yeah.
Okay, what exactly were they talking about? I don't know. Let's move on. Now, we know that it's also alleged that Donna Adelson, the matriarch of the family, it is believed that she knew about the plot or was involved in the murder plot in some way. So listen exactly to this recording of Charlie speaking to his mother about her potential role, where they are talking about how the police are trying to trick them into confessing something. Take a look.
You've done nothing wrong. And it's because of that, you have nothing, literally nothing to worry about. Someone's fishing and someone wants to try to make some money because they're struggling. But that will never amount to anything. So someone's just trying to throw something, throw a fishing line out there and say, how you doing? Throw a fishing line out there and see if they can catch something. And I understand why they're doing it. And I understand what they're trying to do. But it doesn't make it right. But the funny thing is, they really don't make it right. They're just fishing. That's all that's going on. Mm-hmm. And I wouldn't worry about it at all.
Let's break this down. Julie, I want to start with you. We have this petition from this group of friends of Dan Markel asking the state attorney to arrest the Adelsons. Given what we've just heard, and there's more out there as well, if you want to follow the trial, you can always go back to Law and Crime and watch our trials over again. This petition, is the state attorney listening to this? Could it really work? Could the Adelsons ultimately be charged here?
So, it's a tough time. I think many people are concerned because it's been so long, and friends of his are concerned, obviously, with COVID, that things are going to kind of fall to the wayside. The problem many times with these murder-for-hire cases is the strongest cases against the actual shooter or stabber, the person who actually commits the crime. And the person that hires them, the person that puts them up to it, is often the one most protected. That's why they do these murder-for-hires, because they don't want to be the one who's actually with the dirty fingers. They want to have clean hands. And so in this case, you have to prove not just that they knew about it, not just that they might have been involved, but that one or all of those individuals were in fact responsible and had the intent to kill this individual, and prove it beyond a reasonable doubt. And that may be one of the sticking points, but the prosecutor is proving if they knew and being able to prove which one of them, which one of the Adelsons. Is it all of them? Is it the father? Is it the mother? Is it the brother? Which one?
Let's stick with Charlie for a second. Dr. Lang, let me turn to you. There seems to be a disagreement, or there was a disagreement, between what the police wanted to happen and what the state's top prosecutor, or the community's top prosecutor, wanted to happen. My understanding is the former state attorney of that jurisdiction said there wasn't enough probable cause to arrest Charlie Adelson, even though the police filed a probable cause or had a probable cause document saying he should be arrested. What's that disconnect there? How is that possible?
So that disconnect comes because when we're working with the prosecutors are looking at the end of this trial, and that is, do they have evidence beyond a reasonable doubt? And sometimes we as investigators like to use the probable cause to further the investigation. It's important to get the person into the box early into the investigation. So having probable cause, making an arrest, and getting them into an interview or an interrogation and beginning to establish timelines and whatnot is really important for us, and helps to actually build the case more towards that beyond a reasonable doubt that the prosecutor is looking for.
And remember, that former state attorney, Willie Meggs, believed that there was enough probable cause. The current state attorney, Jack Campbell, said this is still ongoing. He even said that in response to what will happen to the Adelsons. As with everything, we'll say we'll watch what happens, and we're going to wait for the retrial of Catherine Mag-Banawa. I want to thank all my guests tonight. Julie, Terry, Dr. Lang, thank you so much for your perspective. Everyone out there, we will be back. In the meantime, stay safe, We'll see you next time.